the textbook, please mention the new page numbers in the chat box. Legal aspects of hospital administration. So legal aspects. There are occasions when there is a mismatch between the expectations of the customers or your beneficiaries and the healthcare workers, healthcare providers. This results will give into grievances when there is a mismatch between the expectations and and what actually you are giving. Okay, what actually you are providing. That's what we call as grievances. Okay, they expect more, but if you are underperforming, if the healthcare sector or healthcare workers are underperforming, it leads to grievances. Okay, every grievance should be reported. It has to be given a solution for as well. Do not let any grievances go unturned. Okay, the judiciary also treats the hospital as an industry. Okay, the court of law in India, healthcare services are also considered as a service sector. Okay, so you are answerable to the Consumer Protection Act, etc. Okay, so there are more disputes and more cases of litigations which are on the rise day by day, because nowadays the consumers are more aware. Okay, we have internets, we do have whatever questions we have legally regarding the performance of a healthcare provider. We can find the correct answers through internet as well, based on the government websites, what the law says. Okay, um, certain similar cases that has took place anywhere. So this information can be accessed by everyone in this generation. So definitely the number of disputes and the cases of litigations are going up high. Okay, so what is law? Law is the obligation on the part of society imposed by a competent authority, and any non-compliance may lead to punishment in form of monetary fine or imprisonment, or sometimes both. Okay, so from the point so this obligation by society means you are you are supposed to, okay, follow certain aspects, follow certain rules. And who has made these rules? Not a lay person can go and make a law. Okay, a competent authority who has the knowledge, who has the power, who has the experience, okay, who has the dignity to make a law, only they can make a law. Okay, so these laws are made by a competent authority, and it is the obligation of us citizens of, as a community, as a society, to follow by the law. Okay, and if at all there is any non-compliance, if you find someone who is breaking the rules or breaking the law, it could lead to any form of punishment. It could be in the form of you have to pay a penalty, you may be put into jail, imprisonment, or sometimes jail along with penalty. Okay, or sometimes community service. Depends on what the court of law has stated for your what the verdict was. Okay, so broadly, there are two kinds of laws. One is statutory law and one is judgment law. Statutory law, the best example is you take the Constitution of India. Constitution of India is the statutory law. Okay, everyone is equal in the eyes of law, based on religion, caste, sex, creed. Okay, discrimination is not done. That's a statutory law. Whatever the Constitution has said, it applies to everyone. Okay, it applies to every citizen born in India. The statutory laws applies to everyone. Okay, judgment law. Some new case has come up. You haven't seen such case in the past. This is the first one of its kind case, and at the end, the case was being fought over for many years. At the end, finally the court came into giving the verdict. So whatever the verdict was, whatever the court gave as a judgment, okay, as a verdict, that becomes the law for similar cases in the future. That is judgment law. For example, Nirbhaya case that happened in 2016, I guess 2015 or 2016, December 16, the Nirbhaya case which took place. In that, government had initiated this concept of fast track court so that such cases are not dragged for a pretty long time in the Supreme Court or High Court. There is another set of court called as fast track court, where immediately the verdicts will be passed on. Okay, so this became a judgment law. Nirbhaya's situation was one of its kind situation, which did after which a lot of laws had been passed. Okay, because of that particular case, when the judgment was finalized, when the verdict was given by the court towards the culprit, okay, it set forth the momentum of what will be done in in future such situations as well. So that's a judgment law. Okay, is it clear between the difference between statutory law and judgment law? Is it clear the difference between statutory law and judgment law? Next, we have ethics. Ethics means your social value. You have your conscience within you, okay? That determines what you do. Is it right or is it wrong? Okay, so the ethics will bind the society by uniform opinion or consideration. It enables the society to decide what is wrong and what is right. We all have this innate, it's our own moral compass. Okay, our an individual moral compass is also ethic. Community's moral compass is also called as ethic. Okay, moral compass can go right or left, okay, based on what your actions, you know yourself what you're doing is right, is the right thing to do, or is it the wrong thing to do. Okay, so that is ethic. Now coming to code of medical ethics. Now it is known as the National Medical Commission of India. Earlier, it was the Medical Council of India. So each applicant at the time of making an application for registration under the provisions of the Act shall be provided the copy of declaration and shall submit it duly signed. As soon as a person finishes their MBBS, okay, they have to sign this declaration. Each student has to sign this declaration. Only then they will be their name would be registered under the National Registry of Doctors. It could be the State Medical Council or the Indian Medical Council Registry, whichever. But they have to sign this declaration, and this declaration is made up of medical ethics. Okay, what they will be following, these medical ethics they have to follow throughout their lifetime, as long as they're practicing as a physician or a practitioner. Okay, so duties and responsibilities of physician in general. Character of the physician. So any doctor with the qualification of MBBS or MBBS with postgraduate degree, okay, they have to be in certain character, that they are upholding the dignity and honor of their profession, okay, and their first choice is to give service to the humanity. Getting financial gains from that, these are secondary priorities. The first priority is to be of service to the humanity. Okay, to be very diligent in caring for the sick. Okay, be modest, sober, patient, and prompt in discharging your duty without any anxiety. Okay, without causing any loss of action, without causing any harm to its patient. Okay, these are the basic instincts that make a doctor of a good character. Okay, no other person who does not have the qualification of MBBS the or an equivalent qualification are supposed to work as a doctor. Okay, maintaining good medical practice, to have to make sure that you communicate in such a way that your patients are confident in you. Okay, the like with your service and devotion, so it should be such that your patients are completely confident in you. You have to continuously improve your medical knowledge as well. That is, even after you complete your MBBS studies or post-graduate studies, you have to ensure that you are attending certain trainings, workshops, seminars, conferences throughout your practice lifetime. Okay, and you have to only practice the methods of healing which have an evidence. Always practice evidence-based actions, evidence-based practices. Okay, this has to be followed by a doctor. Maintenance of medical records. Medical records pertaining to their indoor patients for at least 3 years. It has to be maintained. Okay, from the date of the treatment. Specifically inpatient records, at least for 3 years, it has to be maintained. If there is any request made for the medical record, either by the patient or any other authority, within 72 hours, you have to make sure the medical records or a copy of it is being provided. Okay, do not delay it. A registered medical practitioner will be maintaining the registered medical certificates, and they will give the full details of the certificates which are issued as well. Display of registration numbers. Every physician shall display the registration number accorded to him either by the state medical council or the National Medical Commission, and also on the clinic, registration number has to be mentioned. Prescriptions, whatever prescription they write, the receipt, certificates, medical certificates they issue. Okay, this is given to the patients. All these things should have their medical registration number displayed. And they can display the suffix to their names as well based on their medical degrees. Suffix means doctor so and so, dermatologist, PhD in so. Okay, fellowship done in this many subjects. Okay, diploma done in these many subjects. They can mention that. That is the suffix. And they have to use generic names of drugs while prescribing. Do not use brand names. Always use generic names in capital letters has to be used in prescriptions. Highest quality assurance in patient care has to be ensured by the doctors to safeguard the profession against any admission to it of those who are deficient in moral character or education. Any doctor who is doing unethical acts, okay, is not supposed to work as a doctor. For example, he is an alcoholic, okay, or if a doctor is an alcoholic, or if the doctor is performing a surgery being an alcoholic, okay, not being sober, okay, these are the characters, these are off moral characters which may lead to questioning the authenticity of the doctors as well. Okay, any doctor who is being, who you know that they are practicing, they are doing some malpractices, okay, they are breaking certain acts, okay, they are non-compliant with acts, okay, so this does not come under proper quality assurance in patient care. Not the actions that the doctors take is not in accordance with the safety of the patient. Okay, patient safety is disregarded. Okay, so these things has to be reported. Exposure of unethical conduct, same, without fear or favor. If you find someone who is incompetent or corrupt, dishonest doctors, or unethical conduct has been done by the doctor's part, it has to be reported to the authority. They should expose it. Okay, now even doctors, if they themselves find these kind of situations, they should be the party who will be exposing it or reporting it to the authorities. Payment of professional services. The first priority you should give is to the interest and the health of the patient. The personal financial interest, whatever the physician should may have, it should not conflict with the medical interest of the patient. A physician should announce their fees just before they enter the service, not after. Before surgery, before treatment, consultation charges, treatment charges, surgery charges should be disclosed, not after the surgery or after the treatment has been done. And you cannot come into a contract like no treatment, no payment. Okay, if you do not pay, no treatment will be given. These kind of contracts should not be, is not encouraged. Evasion of legal restrictions. All the physicians should observe the laws and the acts that the country has. For example, Narcotic Drugs, Psychotropic Drugs Act, Drugs and Cosmetic Act, MTP Act, TOA Act, okay, PCLPNDT Act, Mental Health Act, Environmental Protection Act. These are the different kinds of acts which India has. Every physician has to follow all the sections of this act. Okay, these acts are also taught to them. Okay, it is taught to them as well in their training years, and they should oblige by the practice of these acts. Medical legal cases, whoever is the attending doctor, specifically in emergency department, after they do the history collection and clinical examination, and it's the doctor who decides if this is a medical legal case or not. Okay, and if at all it is identified as a medical legal case, immediately law enforcement has to be informed. Okay, the authorities from the law enforcement should arrive, and do not wait for the authorities to arrive and then start a treatment. If this is an emergency situation, if saving the life of the patient is of a priority, you can definitely ask another consulting physician to inform the law and order law authorities, and you can start the treatment to save the patient. Okay, by the time the law enforcement arrives, you can share all the history collected and the clinical examination done. The treatment done so far can be communicated to the authorities. Coming to consent, it's an act of voluntary agreement between two parties or more, okay, in a medical care, and it's the patient and the doctor. Okay, so there are two types of consent. One is implied consent and one is informed consent. Implied consent means it is understood you are in consent. You do not have to write it down, or you do not have to take a signature of it. Implied consent, for example, you are visiting a hospital, you are waiting outside the OPD, you entered the examination room. It means you are consenting. When you are in a consultation room, examination room, you are consenting automatically by your presence that you want to be examined. You are allowing the doctor to touch you for examination. Okay, you being present outside the radiology department, X-ray department, means it is understood that you are consenting for the X-ray to take place on you, or any form of test to be done on you. That is implied consent. Informed consent means it should be oral or written. The purpose, the reason, the future, the effectiveness of the surgery, okay, options other than this surgery, everything has to be explained to the patient or the patient party. Okay, whoever, if patient is in sound mind, then to the patient. The patient is not in the sound mind, to the patient party, or if it is a minor or mentally challenged person, to the patient party, informed consent has to be provided. Their signature also has to be done, and the physician who is going to be the part of the surgical team is the one who is supposed to provide this informed consent. Professional secrets does not under law, the medical professions, unlike legal professions, does not enjoy any professional secrets, but the rights of the privacy of the patient should be preserved unless there's a disclosure agreement which comes from the court of law, or under any legal circumstances you have to disclose the secrets. Only then you are supposed to tell out the truth. Otherwise, you have to maintain the confidentiality of the patients. Then we have privileged communication. It is made by the doctors to an appropriate authority in the public health interest. For example, as an evidence, you give out the information which was trusted to you, to the court of law. If the court of law ask for this information, you have to say it. Okay, for it is a social and the moral duty of the physician for the larger public interest. They may have to tell certain things. For example, you know a person is suffering from a communicable diseases and they are not taking proper precautions to safeguard others. When you get this information, it's your duty to inform the authorities to take the action. Okay, when the doctor has to safeguard their own interest. For example, when a litigation is going on or a medical legal case is going on, okay, against a doctor has been sued. So in such a situation, to save his practice, to save his registration, he may have to disclose the details. Then when a servant is sent by a master, for example, a person who has given given test and everything, and this test results has to be collected by this person, but they cannot come. So in place of them, a servant or someone else can come and collect the results. So you can hand over the results to them. The legal duties of the doctors, you have compulsory duty and you have voluntary duty. Under compulsory duties, notification of births and deaths, notification of notifiable diseases to the appropriate authority, for example, occupational diseases, communicable diseases, okay, AIDS cases, TB cases, reporting of cases of poisoning, reporting of cases of suspected deaths. It could be homicide, something like that. Reporting cases covered under privileged communication. Reporting a call for emergency for military services from if a war is going on and doctors are called for their services to the for the army, they have to report for it. It's a compulsory duty. Voluntary duties which they can choose. Okay, doctors can choose to do or not to do. So to maintain it's unless it is required by the court, the doctor can choose to inform about the privileged consent or not. That's their choice. Consent of the patient for medical examination, okay, and informed consent before conducting any procedure. That is also their choice. If they do not want to take the consent, they can hand over that duty to somebody else. Okay, it's not that consent should not be taken. Consent has to be taken, but it's the doctor's choice. Okay, should I be the person who takes this informed consent, or should I give this opportunity to someone else? To issue medical certificate, that is also a choice. Nobody can force a doctor to issue a medical certificate, fitness certificate, death certificate, vaccination certificate, etc. To conduct post-mortem examination, that is also a choice. Inspection of prison or helping out the healthcare needs of the prisoners, that is also a choice. Attending the cases of accidents, medical emergency, conducting medico-legal examination. So these all are voluntary duties. The Consumer Protection Act, healthcare of the hospitals also come under the Consumer Protection Act. Okay, so we have certain rights. Consumers have certain rights. So under this right to safety, right to be informed, right to choose, right to be heard, right to redress, right to consumer education. This all has to be performed and followed in healthcare community as well. Okay, so this act has been established since 1996, and it has come into force since 1987. Okay, so since then the Consumer Protection Act is applied to healthcare services as well. So patient safety, right to information of the patient, informing patient about their rights. Okay, patients having the choice to continue the treatment or not. You cannot force the patient to go under a treatment. Okay, it's their choice to right to choose. Right to be heard, is the patient being heard properly? If the patient's concerns being addressed. Okay, right to redress. Redress means whatever feedback the patient has given, they have the right to find the solution to it. If you find a solution to it, that has to be communicated to the patient. That is right to redress. Right to consumer education, health education under the hospitals come under this segment. Okay, so this is how Consumer Protection Act translates into healthcare sector. Now, the organization of consumer redressal agencies, we have 3-level organization. So first level is the district forum or the district courts. You have a president here and 2 other members. One should be a woman member, and these members are appointed by the state government, and compensation up to 20 lakhs can be claimed from district forums. And if you are not satisfied by the appeal here, you can further go for the state commission. Next is the state forum or state commission. It also has a president, 2 other members, total 3 members. One should be a woman, and the members are appointed by the state government. If the compensation is between 20 lakhs and 1 crore rupees, that is what the patient is asking for. Okay, if that is the compensation, then in the state commission you have to file. If the compensation to be claimed is much more than that, you have to go to the national commission. President, it has 5 members, president, and 4 members. One should be a woman. Members are appointed by the central government. And if the compensation is exceeding more than 1 crore rupees, okay, the penalty or the compensation that you are claiming, if it is more than 1 crore rupees, it is taken care by the national commission. And if again you are not further happy with the processes here, you have to go to the Supreme Court. Next we have is the law of torts. So law torts, it's any wrongdoing. Okay, the meaning of tort means any wrongdoing to a person for which a civil case can be lodged. So this is under the civil cases. You have done some wrong to somebody. You trespassed into somebody's land. Okay, trespassing was there. You hit somebody. You publicly humiliated someone. These all comes under the civil cases. Some wrongdoing was done. Cheated someone. Okay, did some forgery. Okay, so these all comes under law of torts. So intentional torts, wrongs that is caused by the defendant by deliberate action, purposefully causing harm. Okay, like for example, physical violence. Physical violence is intentional. Okay, so that's intentional tort. Battery is intentional. You're touching someone without their permission. It's intentional. Okay, the next you have is negligence. Wrongs that happen because the defendant owed a duty and failed to act reasonably. This could be unintentional as well. They may have forgot, or their actions mismatched. Okay, their actions were delayed, something like that. Okay, it's not always intentional. It could be unintentional negligence as well. Okay, they are supposed to do a duty, but they forgot it or they failed to do that duty. That comes under negligence. It's a type of tort. The strict liability torts, which is like you do not have any further proof. You do not have need any further proof to prove a wrong has been done. For example, wrong surgery done in wrong patient, wrong blood given to wrong patient. Okay, you do not have to prove anything here. It is very much evident that a gross negligence has been conducted. Okay, was it intentional, unintentional does not matter. But given the state of the patient, it is completely seen that a big negligence was being conducted. A gross negligence was being conducted. That is strict liability torts. So that's about the legal aspects of hospital administration.